Yeah, we're definitely into the fourth season. It's hot. I don't know about where you're at. It's almost climate change hot, waiting for the ocean to come pouring in on me behind the woodshed. The BTWRLM226, I believe, as we move into the end of the year. Pretty fascinating how fast this all goes. Kind of a blink of an eye that ain't. We have just enough time to see how much we fail and make excuses for it. I was kind of talking in the UCY chat just before and listening to people on the prior broadcast. It's fascinating to me how people generally will fabricate more fictions, decry the fiction, and make more fictions in order to try and avoid what we have to actually do and understand. We make these fictions up in these fictional fairy tales, and for some reasons I haven't figured out, and then someone like myself comes along and says, listen, there's a reality. We've gotten here by some method, and we necessarily need to pay attention to that. We need to start to understand how we got here in order to understand how we need to actually become more aware of how we're going to move forward. And we are given the opportunity at the worst time, seeing the worst of it, to actually make those guidelines, those foundational places that haven't been made up until now. That we're here today is because we haven't made those foundational protections. So going off and making fairy tale answers and making up new terms, as I now understand out of the words of the mouth of someone who presents this all the time, they're actually making up the word anarchy. As I was telling you, there's no basis for what this new word is about. It's just something coming along. That's not going to get us there. And so I guess I'm finding a way where I'm taking the issue with all this. Maybe why I don't have quite the listenership that I would have thought that people who really wanted to do something would have started to key in on and follow. And I say that with a little bit of authority in that over the numbers of multiple years that I broadcast, nobody really comes with anything more than questions on how to further what they want and get their thing going, which is what I'd like to see you all doing. Not making the excuse. Just find the wrong you need to make right and move forward. Start to understand it. I've told you some of the pitfalls. I've told you that there's no reliance in the system itself, and that's the problem. It didn't start that way. It wasn't created that way in governments that were set up that were outlaws at the time. And I specifically referenced the miners. I don't think people appreciate this little anomaly in the world, in the history of man. Men got together in protection of themselves and against outsiders, the Genghis Khans, the criminals that would come in and steal from them. And they created for themselves a law of peace and a government to oversee that was neutrally applied. And I don't understand why everyone denounces in the generic government generically without going back to why we got here. And even as late as 150 years ago, we were killing each other until we brought ourselves together to make the rules that worked, even if we were the outlaw ourselves against a greater so-called power. And I say that advisedly. The power was really just a war power, and then this non-dependence, this outlaw existed nonetheless. So there's a great example we can take. We don't have to go to fairy tales. We go, what the reality was. We start moving from there, and I think we stop having to waste a lot of time, all the millions and billions of hours, man and woman hours, discussing nonsense and not getting anywhere, I guess is the thing I see. Talking with people throughout the week, it's really amazing what absolutely well-meaning people just really got it in their heart to make it better and have a completely misapprehension of what they're up against. And this is who we are right now. And this is, whether it was planned or not, I say that's not an excuse. Come behind the woodshed, learn the principles, and then go back out and make a better future. So this is one of the ways that you keep yourself protected, even as an outlaw against somebody else. In this case, the outlaw is the good guy. And to show you how inverted things are, when I reference the miner, in the days of old, because now we don't have a sense about how it actually is supposed to work. And this is after the construction establishment of the United States of America by its Constitution. In there was it wasn't so perfect. When they had to make amendments right away, you had to start. You should have understood that we were in. This thing was still in work. It was still being made. we had to understand that there was warnings put out, that there was things that we're obligated to because we decided to come together in another way, maybe a larger way in the world, to form up a nation of people, however we want to characterize it, and however the truth of the certain exploitations. We had it in our hands at that time to stop all that nonsense. And we were told we were going to have to. Now, I wasn't around then, and so I can only take it on what I've read and what I've seen, and I can only now then, more importantly, in the recent decades, read, research, find the mining law, find the mining districts particularly, why the miners were together to make their own government, even as outlaws in the United States of America, and how that worked, and who they threw out. It would be a good example to start with. I don't know if you've heard me say it, or if you haven't done any study, and if you've never even thought about it, but miners were known, just notorious for throwing attorneys out of their districts. Notorious for it. You may not have existed too long if you went in and mouthed it off too much. You find yourself getting run back out on a rail, maybe with a little bit of tar and feather on you if you were lucky. And so there was nothing to joke about here, about how we're being taken down. And we come to the year 2017, we think we're all exalted and we got this figured out. Can't look around and find nothing but problems, can't figure it out, don't understand why we're just barely able to defend ourselves in our home front from all kinds of different attacks that really aren't peaceful. The bottom line is, when we weren't peaceful to enjoy our lives, there should have been everyone should have looked around and said, okay, who's making the disturbance? What is making the disturbance? And let's kick that thing to the curb. Let's do it during a nice swift rain and maybe wash it into the gutter and down into the drain and down into where Mother Nature will take care of it. But no, we let it keep coming up around us, to the point where those same folk that we were told to beware of, woe unto ye lawyers, woe unto those that would enter in and pretend to tell me about my own property, as the miners did. How dare you come in and tell us how we have existed to protect ourselves, maintain peace amongst ourselves, and protect us against the encroachment of the outside. And I say that particularly because wherever you find real wealth, you find someone wanting to come and steal it. We were admonished. We were admonished not to be greedy, and we were not to steal. And yet there's some people out there that won't do it. That's the reality. I don't like it, but that's the reality. So what did people do in order to make this thing work? Well, they said, first of all, to make it actually valid, there was actually a problem. First of all, notice is required, but then there was this thought, well, we all know that murder's no good. In fact, if we didn't have a better thought, we would have a problem with that, unless we were miswired, and there's a couple people that might be. But for the most part, we know it's not right to murder someone else. So those types of natural law violations were notice enough, and so that we didn't need to have the notice like of the other things, like when you got into having to deal with people, because there was between the two, there was a big problem. And between the two, neither one of them could actually answer to the big problem that they had developed or found themselves into, because one stubbornly wanted to believe their rights were there, and the other one stubbornly wanted to believe their rights was all right, and they might have had equal right to consider that. But at some point, we had to come to terms with those problems, even in the most peaceful place. There's never a peace, it seems. And so we made rules. And those things were now called laws. And however you want to define them and structure them, they can be called all kinds of things, and then you have to look at the jurisdiction. But the point was we had to come together to make general reasoning about how we would deal with problems. And we'll have to call those laws. And that's what we all were given notice of when we walked into a jurisdiction. And this is really prevalent in the mining districts. You had a whole bunch, the regulations of the district were how you carried on yourself within that district. And that was done for a reason. And it was essentially to keep peace. Essentially, the first point was keep peace amongst the miners, and then to keep protection against the outside intrusion. And the notice gave everybody no excuse. And then they jumped on this idea that ignorance of the law is no excuse. Now, that's been a little bit contorted when it went to administrative rule, but let's just keep it back in the law. So you're not supposed to be ignorant of what you're obligated to do that was done by others to protect them and you and give everybody the objective basis on how that was going to be dealt with by a supposed third-party individual or a group of individuals called the jury that, in this case, in the jury, they were all landowners that if they decided wrong in a ruling, that could affect them. So they were a lot more intelligent about how they did their thing. That didn't mean that you didn't get convicted and hung by the neck until dead within hours after you got brought before the jury. But the point was, and there was a lot of people that didn't like to hear that, and it's maybe harsh, but that's what happened. And there's a history that we come from that gives us a foundation from which we have to keep going. We have an ability to protect ourselves. We have the law can be a tool that way. And so I'm not so negative on certain laws. And I can do that specifically to the land disposal law, the law of the land. Not the one made up, the common law by the judges, the law of the land. The law of the land is the common law. It's called the law of the judges, and people don't quite get this. And then we moved on from there. So there's a whole lot that we could talk about. Again, I'm talking blind to a whole bunch of people that I don't know may or may not be blind, and I've got to generally cast information out, and hopefully something triggers that you need, or maybe enough to maybe ask additional questions. But when I hear people, like I was hearing before on the broadcast at UCY, and as I commented in the chat, that they're I've called it all out, so it's just I want to keep the innocence of everybody until they actually admit it to themselves. That's the best proof I have. And it was just admitted that that term anarchy is really a new invention now. As I pointed out to you all, we can't do that. We have to go back to some tried and true reasons about why we're here and start from there. As I said, we don't have to reinvent the wheel, so why are we trying? And especially when we're so dang ignorant. We're just so ignorant in what we don't know, and we're so ignorant about how ignorant we are. And I'm not going to sit back here behind Woodshed and claim to be all-knowing. I'm only focusing on what I've been shown and told and moved through this, remembering this mining law and what was going on there and how prevailing this thing really is when you get to the law of the land and how it does set up objective, organized notice to people about how they're supposed to conduct themselves and what it takes to do certain things that everyone can then understand that it's been done at least as best as we could figure to do it. To do what? Just to keep the peace amongst ourselves, which presumes upon us this fallen nature that we can resort to as people. And we do. And that's the problem. And so the highest minding sounding ideas are going to meet the wall of those that don't care about that. And we can identify them by many names. We can go over to even to stakeholder. Genghis Khan and his horde is a stakeholder, but when all they can do is affect you adversely, that's just somebody coming to steal you blind and take you down. You'd be lucky just to have your stuff stolen at that point. But that's why we set up some of these laws and things. And then it's gone on and kind of gone on. But getting back into what we did to protect ourselves, not only have we certain things come up, and we have the Second Amendment showing that the Constitution wasn't so perfect. A year later, they had to make amendments to it, and so it just shows that we can do these things for ourselves. We have it in us to do. We have the power. Another thing that was presumed as evil, power outside the world is evil generally, and that's a misstatement and it's a misapplication because power, it all depends on how it's used. And I would say you each have a power. So I'm not going to condemn power in the generic. So somebody that wields power means that you either aren't wielding your own or you've been oppressed, and either one has to be fixed. So how because we're not so easily rendered to peace, we would much rather need to club each other in the head, raises the idea of warring amongst people. And then groups of people, and you want to talk about the tribes and going back to tribes, it'll start over again. That's another revolution. You got to stop this. We may be of a so-called tribe, but that definition is being actually driven by the new global governance crowd into nonsensical areas, and we don't stop that and create the reprinciple ourselves. That we found out pretty quickly we needed armament to protect ourselves. I used to be, as I've said before, a medieval armor maker. I also figured out I was into medieval safety equipment. And what that was is because people of the time found that they needed to protect themselves, and they used armor. Well, they also had arms. And arms at that time was swords and knives and shields. If you knew how to do a shield, the shield could be a very nice weapon, and other things. And so we are a people, men and women, that are warring. So we have a fallen nature that will war, and we have that may be justified when someone attacks us in defense. But the point is, it's all out there, and this issue of defense of one's own self and family and property has been ingrained in us for a long, long time. Well, the founders came along and they said, well, they didn't do it right off the bat, you noticed. They had to amend this in the Constitution after someone started looking around and said, this government we just created, one of them said, I smell a rat. That was before it even got made. And I've shown you, if you go look at the Article 6, I believe, it shows you that there was a big problem. Big problem. So, it wasn't so perfect. So people got fearful of what they had created, and then they amended the Constitution to include these 10 commandments of the Constitution, the amendments. One of them is the second one. And I guess you can go with the entry of priority as the entry of how important it is, but I'm not so sure I agree with that. Because if you can't protect yourself in any way you need to, as the first rule, I don't know what the first rule would be that you could have that you could protect in importance. But the second one that they made wasn't the first. It was the Second Amendment in the Constitution, was the right to bear arms. Keep and bear arms. Keep and bear. I want you to remember that's the phrase. Keep and bear. And this is something I'm not going to go maybe on more than these reports here. But this is how the dynamics go, and I want you to see historically who's been invading your rights, who keeps getting in the way, who the miners threw out of their mining camps, and who is in here arguing these things. And this group has sing the praises to the UN, and the UN in a courtyard has a pistol with a knot tied in its barrel to show you what the rigmarole about all this is. And don't ever forget, the Bar Association is a trade association, a professions association that promotes itself. And so when you hear these discussions coming down from judges, that just maybe they're helping to promote the work, like a union, promote their workers to have more work. And we never really get to what the statements are. And if you look through long enough and you read long enough, you see that's how it's all set up. And so it's another trap. We need to be speaking on our own. We need to invoke our own power. And when we don't, those that have taken it and pretended to take it will rule the day. That said, there's lots of questions and ways they go about this. These occupiers on our territory have to go about things a certain way. And when you start actually agree to that, when you finally see that yourself and then see that that's the way it works, you realize why things take quite a while in this system to convert it over into where it is planned on going, because you didn't actually keep to your plan, which was to keep peaceful and to keep non-dependent on a system that was supposed to protect you. And this I can only see this at this point from the law of the land disposal grants, acts of Congress, how the government all works out. They're not in a sovereign capacity at the point of the grant. And so now we get away with the sovereign immunity nonsense, which starts to show you that there's chinks in the armor of government. We just forgot or didn't know how to look at it. Well, this Second Amendment comes in, and the people are supposed to have a right to defend themselves. But if you look really carefully, it's not about anything you hear today. In fact, I'm going to read a couple of issues that just came up. Actually, a couple of weeks ago. I can't get to all this stuff. I wish I could, but I can't. So that there was a kind of a favorable decision made, but I think it's only to further the question and get the question again before the Supreme Court, the way this thing all works out. On something I don't believe is really rightfully a question, but this is what the lawyers do. They'll make a question out of something, and then they get to dispute it, and then you get to have the rights they gave you, instead of you protecting your own, instead of you stepping up and saying, hey, I have these rights. And I'm going to try and present something here that shows you maybe as an idea what may be missing on this Second Amendment, that you shall keep and bear arms. But for what? Does it really say, is it only about personal defense? Well, they're trying to constrain it to personal defense. But in fact, what it was one method. It was one weapon you had against an oppressive government. It was to alter and abolish the government as you saw fit. And firearms, excuse me, I just misstated. Firearms are the statutory recodification of a term that's special in commerce. You had the arms, just arms generally. You had the right to keep and bear, to control, be a tool to control that. And so that seems to be the constant, all these years I've watched, is a constant misstatement. And I don't think they bring it up, because if they brought that up, it ends the discussion, and the Bar Association promotion and the ability to ka-ching y'all over these discussions and get y'all fired up and make all these associations of people attempting to protect their rights, because the government can come and can take them, even though the contract was not supposed to be that it wasn't. The grant of the people to the government is supposed to be protected on its face. So if we're questioning this, has always been my question, and it's really not a question. What in the heck are we letting these attorneys make these decisions, and they set up this constraints, and they set up the questions to answer, and they answer them a lot of times odd, if not completely wrong, but always consistently down the path of slow and incremental totalitarianism, bringing on no remedy. A D.C. federal court just ruled carrying guns in public is a core Second Amendment right. I really hate the consistency of the words of destruction, core, like core education and all that. But here we have it. There's a core of the Second Amendment. When we read through this thing, it's pretty interesting because they don't really touch what the core principle is. They keep beating around the bush. They talk in ways that imply there's something bigger here, but they don't really speak to it. And it's the thing I just told you. They won't speak to the fact that this right was not only it was the right to protect yourself, but it was the right to go against the government that was established when it went bad and there was nobody else within the government. It went complete caucustocracy from top to bottom, and you needed to overthrow it. Well, now we're in another day. I don't think that Second Amendment will help us much. I still find it fascinating. I can't have a rocket launcher, and yet the guys over in Syria, the rebels, can. And I'm supposed to have a right to bear arms and protect myself against a rogue government like the kind we have going right now and have been for decades. And yet, a federal appeals court on Tuesday struck down Washington, D.C.'s latest attempt to limit residents' right to carry guns in public. When I just saw that, I'm not going to go through all the problems with these decisions on this news art thing, but understand there's so many words in here that condition this thing down to a specific status that may not apply to you if you know what really to say. And before I go a little on to read this again, as I was thinking. So we were given, the amendment was made to the government. You have the right to bear, keep and bear. It doesn't make a limitation, just keep and bear for the protection of you against the government itself, as well as yourself. But where did that yourself stuff come? That came antecedent the government. That was something in you. That was the natural law. Every man or woman has the right to defend themselves against any aggression. That's already in us. And what you're going to hear when I finally read through this, you're going to hear that they hashed over the historic principles, but they don't talk about this as a right before government's institution. And this is the thing that you start to have to make your short list. Well, that case did not speak to the antecedent right of protection against any aggression, any encroachment, we're talking about like physical attack. And so remember not to be listening that someone else is talking in all of your rights. You have to have a principle in you to say, wait a minute, I have some things I have a right to do, and these conditions encroach upon that, and I shall have a right to keep and bear. Without limitation here. And this is what I also see, again, missing. So the U.S. Court of Appeals for the D.C. Circuit held in a 2-1 decision that public carrying of firearms is a core Second Amendment right, and that the district's regulations amounted to a total ban on exercising that right. The ruling breaks with several federal appeals courts that upheld similar regulations in other states. Now, what I think is going on here is you have to have a controversy within the district, within the courts, in order for the Supreme Court to hear it. This makes that question. What is going to be now the overall rule? What will the Supreme Court now, having to weigh in on this problem, say? And I think this was a set-up case that way, and I'll be very interested to follow how they use it. But This is now the court that came out to say different than other district courts. And I'm not touching the fact that they're all incompetent. At this point, the D.C. court might be the only one, except for this is a D.C. circuit, so I'm not so sure that the original court had jurisdiction over this Article 3 matter. But notwithstanding all that problem, let's go on to read what they're saying so we can identify how they're messing around with this. And I don't know how you feel all about it, but I think this is, again, examples of how we can be funneled into a thought and not think about the external rights that we have to bring forward to say these are being encroached by your infringement that I shall keep and bear, and your rule encroaches impermissibly upon that shall keep and bear, because I have these other things that you didn't consider that are still viable notwithstanding your limited statement, and you didn't have authority to make that limited statement. So now there's a problem with the courts of appeals now. The quote, for the long struggle against gun violence. So understand what the infringers are saying, gun violence. Well, that's kind of redundant, isn't it? I mean, I don't know any gun that would be used not in violence. You're not supposed to use it for frivolous matters. And I don't know if the violence here is unauthorized because of the way they twist the words. I said, if violence has no warrant, yes, we have gun violence, and that's not tolerated. But that's not going to be stopped, and we all know that the lunacy behind trying to what prohibition doesn't work. Let's just put it that way. But let me go back to the quote. For the long struggle against gun violence, you might see in today's decision a defeat. You might see the opposite. To say whether it is one or the other is beyond our ken here. We are bound to leave the district as much space to regulate as the Constitution allows, but no more. D.C. Circuit Judge Thomas Griffith wrote in a majority opinion. There, did you hear the dangling Chad, the chasm of statement that's not being spoken to when he says we are bound to leave the district as much space to regulate as the Constitution allows, which means the Constitution allows something and greater than what the district did. And you're never going to hear what that is in these cases. And I'm telling you, it's the power that you have, a couple of things, but at least this one right up front, that Second Amendment was made so that the people would have, without question, the ability to use arms to defend themselves against a government gone bad. I'm not advocating that, folks. I'm just telling you this is the way we see and show how we're being interfered with and encroached, and how they do it, and how they constrain our minds. I don't think that's the way to do it. I don't think we're prepared. We're not organized. When I hear the fairy tales on the internet that are going around, we are not of peoples around the world, even in the United States, that are ready to understand what our responsibilities truly are. And I think when we go there first, we'll find out how quickly that didn't work. And I think Lincoln made that rule for us. The article goes on to say the United States Supreme Court ruled in 2008 that people have a Second Amendment right to keep guns at home, but the justices haven't decided whether the same is true for public carrying. The Supreme Court in June declined to hear a case similar to that heard by the district about public carrying regulations. Justice Clarence Thomas and Neil Gorsuch said they would have heard that case. The D.C. case could present another opportunity. And this is a serious problem that I didn't get to report on, is passed on, that there was a California case, I think it came out of San Diego. Someone said, I have the right to carry concealed in public. And they would not hear that case, the Supreme Court. When you hear it in the first part of this paragraph, the Supreme Court will decide. See, they're not supposed to decide. They're supposed to tell us what the law is and the extent. And you notice they stopped short earlier when they could have just defined that the Second Amendment was for all time. You shall keep and bear at all times and in all places. There was no limitation. But they don't do that. And I think that's the cha-ching of the attorneys promoting themselves and getting you to have to go to them because we're too stupid to do it ourselves. And the process they put on us, too stupid to follow that. And then there's all convoluted. When you get inside there, you find out how they do it, how they mess you around, and how there's no justice in there. And I've got my name on a default judgment that shows you that there is no justice. It's kind of denial of justice that happens till today. So why would you walk into that circuit, that system, and actually ask this question? is asking for them to the decision. What did Scalia say? Well, you came to us for the answer. I've told you about that. That was a big clue, folks. But the article goes on. Before the case reaches the justices, though, the district attorneys could first ask a full sitting of the D.C. Circuit to reconsider the panel's decision and hope, if they get a favorable ruling, that the Supreme Court remains disinclined to take up the issue. One member of the D.C. Circuit panel, Judge Karen LaCraft Henderson, dissented from Tuesday's decision, and we'll hear in a moment what she said. And again, it's full of this global governance nonsense about what they're trying to get you to think. And here it comes in this sentence by the district attorney. The District of Columbia's good reason requirement for concealed carry permits is a common sense gun regulation, and 4 federal appeal courts have rejected challenges to similar laws in other states. Racine said the Office of the Attorney General is committed to working with the mayor and the council to continue fighting for common sense gun rules. Well, common sense is it's nonsense. The common sense they're talking about is this community, the communitarianism, this thing that they're putting on the international imposition against gun use, while a gun use that's regulated by government. Nothing in the Constitution Amendment Second provides for any of this common sense limitation. I guess is the point. This is them coming in to say that there needs to be common sense. Common is communist, and in the political sense, there's going to be a knot tied in the barrel of your gun. You may have it, but there's going to be a knot tied in it for all practical purposes. Another statement in this article, as I'm jumping here, kind of going along, you can go get it in the Blogcaster eventually, or just type it in and find it. Quote, Americans, and this is the big championing statement, but we'll see. Americans need not prove to the police a rare and special reason to exercise fundamental rights. Of course, the decision today still leaves Washington, D.C. with some of the nation's most stringent handgun laws. It does nothing to alter the city's restrictions on where guns may be carried on a safety-based carrying rules. It just means the city may regulate rights, not remove them from people's reach altogether. Folks, if I look at this grant to government as a prohibition and tie that over to the mining law and say that a grantor only grants what he grants by expression and nothing's to be inferred or implied from that, there would be no way that that safety-based limitation and restriction could be placed on this amendment. I'm just putting law of the land law on this point, all by itself. I don't need a great lengthy discussion, or don't need more proof. There is no restriction. It doesn't say a right to keep and bear arms based on regulated by some safety-based carrying rule. In fact, if you look at the mining law, just a reference, it says that you can be regulated as a miner, but only over the establishment of the title itself, how you claim. The rules on how you claim creating the title is what is regulated. Everything else is self-initiated and self-determined by the grantee. And when you understand what I'm saying here about this foundational basis, you'll start seeing how funky this whole thing is and why it shouldn't be carried on, and where is that discussion here? It should be really prevalent in your mind. No, we're talking about safety-based carrying rules. They say, oh, that's police power. That wasn't a power to the government to make safety-based carrying rules, was for the government itself, folks. That's why they don't want concealed carry. They know that you have the right to go alter and abolish the government as you see fit. I'm not advocating for violence. I'm not advocating for even a justified use. I'm saying that what they're saying safety-based is public-based, which is government. Public is government. And they're trying to bring police powers into this, and it didn't even say you have the right to regulate shall keep and bear by police powers. They've imposed all that. Now, why wouldn't they now come up with this rule against the government being able to constrain your ability to attack their oppression? Why wouldn't they? And so this is an interesting problem that I see, that everyone agrees in these common sense things. Now we have what's police power-esque safety-based carrying rules. Well, if that was true, safety-based carrying would be, well, how do you keep it safe? Now, I don't know if I've ever heard so many people dying. Well, I've heard of them. I've lost some friends due to carrying improperly, and they shot themselves. It had to do with a gun and a mechanism in the gun that triggered when it wasn't supposed to, and they'd each one of them shot their leg, an artery sufficient that they died in the forest. So we'd like to see some safety there, but it doesn't mean you don't have the right to carry, and you don't have the right to carry wherever you need to. The article goes on to say, Griffin, joined by Judge Stephen Williams, wrote in Tuesday's opinion that it was more, quote, more natural to view the amendment's core as including a law-abiding citizen's right to carry common firearms for defense beyond the home, close quote. He added that this right would still be subject to restrictions on carrying in sensitive places. Now, where in the Constitution does it say that it will be, shall keep and bear, is limited by sensitive places? You triggered SJW Warrior. Oh, actually, SJ Warrior, I guess it is. I've said that twice. See, they put these little twists on that, and there's no provision for it. And I wanted to give you a reference in the mining law. Where there was a provision to regulate miners in mining law and the claims, it was only on how you acquired, what it took to maintain the claim. In other words, the paperwork that you needed to file so that everybody understood exactly what it is you were talking about, where and how and the extent and all these things. These things in property that we understand that provides the public notice of where y'all that don't have exclusive possession should stay away from and leave them alone. I don't see the Second Amendment as anything else. They amended it after knowing there was police powers, and they didn't include anything in there that said that it would be conditioned by that. Why? Because you can't condition an oppressor. You can't give them a license to oppress you when your right to do that was to stop that. It's him, it's that. Lawyers in the district, for the district argued, and this is for the government, argued the Second Amendment was intended to protect the establishment of state militias, not personal defense. But Griffith said that the Heller case held that, quote, the reason for the amendment's passage did not narrow the sweep of its protections. Again, they are implying a greater use and need in that thing that they're not talking about about this amendment. The reason for the amendment's passage did not narrow the sweep, which means there was a more comprehensive utility need and statement there. And so you see these guys are talking in riddles in some regard. If you just kind of read this and not pay attention, and you look at some of the words and you think like they're talking about something in a good sense. No, they're hiding the underlying reasons. I've only kind of highlighted one. I'm going to maybe get to the one here that I'm looking at as I get down here and get reminded of it. Another one sits there about these so-called secure, sensitive places. The case delved into what Griffin characterized as, quote, dense historical weeds, with lawyers drawing on precedents, picking and choosing, and examples of gun laws stretching back hundreds of years that may have influenced the Second Amendment. May have? That's our law? May have? See, this is how they start to dilute your authority when you handed them the right to make that decision. Someone should have moved in here and said that none of you folks have the right to make a question on something that says shall, keep, and bear without further limitation. Not even your so-called highest-minded legal impositions. It didn't say that even that legal imposition could do that. All it says is that the Supreme Court, would decide the law to the way it was written, not make up stuff. And they've made up nothing but stuff the whole time. But Griffin wrote I'll read back. The district pointed to a ban on public carrying of guns in the crowded areas dating back to the 14th century to support the need for restrictions in urban areas. Works, well, there's urban areas in the 14th century. Was there? No, that's been an invention here of the urbanites, the academia to destroy ruled the countryside. Urbanites. There was did the 14th century have the Second Amendment? So we can we can talk a lot of nonsense and we can kind of consider it, but ought we when there was no limitation? No, it was irrelevant, actually. If you made a new way, as far as the Constitution, why would you look back at the 14th century unless you were trying to dilute what that provision was about? But Griffin wrote that by the time the Founding Fathers wrote the United States Constitution, the right to bear arms, quote, was thought to protect carrying for self-defense generally. No, it was already antecedent. What they actually stated was that your right to the arm was to keep and bear against the oppressor, the government. So we see that these so-called judges are, I think, for certainly are getting it wrong. And they're not, and based on how I'm analyzing it about grants and the prohibitions and where the limited forms when you look at the law and how it works, they don't have the authority here, no jurisdiction or authority, notwithstanding the Supreme Court may have it. These folks don't have the right to even question this. They don't have a right to have an opinion. And when you see what their opinion is, it doesn't meet what the words say. These are facially errors. But this is the facial error that's going to be going as a conflict amongst the appellate courts. Quote, common law rights developed over time. American commentaries spell out what early cases imply. The mature right captured by the amendment was not hemmed in by long-standing bans on carrying in densely populated areas. Its protections today don't give out inside the Beltway, Griffith wrote. You see, there he misses it. He doesn't state it again. He talks about it maturing now. It's gone beyond. When it finally gets to the Constitution, those folks, the so-called Founding Fathers, said, no, we got to make sure that we write in here that we folks have the right to defend ourselves against the oppressive government when it goes there. And we can use the arms to do so, any arms. It's not related to common arms, as the other thing that we heard just a little bit ago. See, there's making limitations at every turn. This is a matured right. It started out as private protections against anyone that's aggressing you in a violent way, not a warranted way. It's matured beyond even that, is what he's saying here. And yet he won't tell you what that is. There's always how an interesting insight. I would laugh if it was funny, but this is how they take us out. We are now constrained by their statements, and we start quoting these out of case citations thinking that's what we want to say. Oh, that was high sounding, let's use it. But when you look at it in context of the subject matter, and then remember, this is only applied to residents in a non-state, that they're agreeing the Constitution applies to that non-state district. They said district, not a state. You got to watch how this all works. That they're conditioning this inside that non-state district. May actually be okay within the district, but it doesn't still fulfill what the statement, even in discussion of what the Second Amendment is. They do it in a obscure way. The mature right. Which mature right was it, folks? I don't think it was a written agreement in a bunch of people that said, no, we have the right against the government we formed, and we shall keep and bear arms for that purpose. I don't think that was really ever done in history, as far as a open letter, if you will. That was the mature point. We finally came to terms that governments are criminal. And I don't mean all governments, because I've already given you the mining government, which when you look at it in its basic essence, wasn't criminal. It was a people keeping laws, regulations amongst themselves on what the objective basis would be on how you treat each other inside, and then protection of those encroachers and trespassers from the outside. And when it came to the government, and being the outlaw that the mining districts were at the time, when the federal government came after them, what did they use to protect themselves but guns? And what happens in this battle? The miners have always taken it pretty hard, but they still fight, or they used to. Not anymore. They're panty wastes now. They can't even write a simple letter on point. And if all y'all miners are listening right now, maybe not you, but most of you, you can't write a simple letter. How are you going to go out and protect yourself? Come on. Now, so the miners are old. They went to guns to protect themselves as an outlaw to the federal oppressor. And what happened? Finally, the courts decided they're going to, if they don't fix this thing up and make some interesting decisions on point of the law, that we were going to have nothing but continued bloodshed. That wasn't peace, and that wasn't keeping the peace. And in 1864, the Sparrow case comes up and says, Congress, because you forbear to allow these people to trespass and gain the minerals, you owe them those minerals. You can't steal them. One year later, the states were told, and the corporation said, you can't have the minerals unless we say so. And the next year, the 1866 law was, okay, miners, you can have those minerals on grant, and here's how we're going to do that. You told us how. Your laws and regulations will rule this, because we're incapable. Didn't take a bunch of lawyers, folks. But they went to guns in order to protect themselves against the army. And they took hits, the miners took hits, but that's what they were defending themselves against their oppressor, who ended up finding out that it was an oppressor, because there was an obligation on the Congress to dispose those lands to the people in the state. Not residents, the people, the men and women in the state. That was the purpose of your enabling acts and the cession back to the federal government. So applied to that, and then we go to the Second Amendment, you'd see that there wasn't an outlaw. It wasn't a crime, a constitutional crime for a miner to put a gun against a federal agent coming to oppress them. Where was their warrant? You find out shortly after that there was no warrant in the federal government to attack people just producing minerals. In particular, the ones that are of national security interest to the government itself. How stupid are these people in government that they did that? But the people, the men and women, won that out, even though they lost lives. They needed guns to protect them and prolong the oppression, it didn't prolong the attack, it actually shortened it, but they needed to not be overrun, and the arms that they kept and used allowed that for the time for the oppressor itself to decide it wasn't right to do what it was doing. And peace then reigned over the land. Common law rights developed over time. There's about 4 or 5, maybe 6 or 7, I don't know how many there are, I keep reading around, so-called common law rights. What we suffer under today is common law rights. It's judge-made law. It's not law-made law. It's not antecedent acknowledgement law. It's made up, and it's this diminished thing. And what it's diminishing from and to is taking away your rights, because you're not speaking out. You're being crickets. Common law rights developed over time. One of the rights you had was to self-defense up front, and then the matured right was that defense could be against even the government that's supposed to sit there in service to you. And I keep thinking I have to say this. I'm not advocating using the Second Amendment. I think that would be the dumbest thing we could do right now. If we don't get aware enough to be able to realize we don't need to do it, we really don't need to do that now. And until we realize we need to put ourselves in a position that we can actually get rid of the problem, we're certainly at a tactical disadvantage, aren't we? Let's start using our brain. And I don't think if we go there that we've arrived, folks. I think we can do this in a much more peaceful way. And I think the problem is the accountability. I think when we actually start bringing accountability, we start cleaning up. We clean up that swamp that exists all around us, everywhere. Going on to this article, again, and almost done, the dissenter, Henderson, wrote in her dissent that the right to have guns at home for self-defense is at the core of the Second Amendment. But that was not the case for public carry. Applying a less rigorous standard for deciding if a law is unconstitutional, Henderson wrote that the District of Columbia, again, a district, not a state, had shown, quote, 2 important government objectives underlying its licensing regime, the prevention of crime and the promotion of public safety. Now, that's got to be an arbitrary and capricious decision, because we know that a prohibition against something actually causes more problems. If I don't have the right to keep and bear arms, someone's gonna come and get me. They're going to figure me out and take my stuff. That's not preventing crime. Promotion of public safety, when you don't understand public is government, it's the promotion of government safety. They don't want these guns around in people's hands. And they certainly don't want to educate you as to how to be responsible anymore, because that might show you how irresponsible you are in other areas, and we just might become an aware populace again. But notice they said licensing regime. Licensing, if you look at every other state, and I think in the District of Columbia as well, it's a permission to pursue a trade, occupation, or profession. Keeping and bearing arms is not a trade, occupation, or profession. It's not in commerce, folks. So, How are they able to apply a license to this? It's always been an interesting question that none of them will answer for you. It's the same problem. How can you apply a permit, which is the same license, permission, to do a commerce act? How are you able to apply a permit to a grantee who has a right to extract non-commerce production? How? Well, the attorneys won't tell you. The government won't tell you because they're the oppressor. Now, we ought to be able to protect ourselves with a gun. Now, that's not going to be so smart. But a lot of miners could get together. A lot of people who understood this a lot better could not come with their guns, although they ought to, because here's another problem I'm going to point out. They could come to do an arrest. Well, the promotion of public safety is the promotion of the government to continue to oppress you. Government safety is the ability to oppress you. This amendment says that I have the right to go stop that oppression, and I can use an arm to do so. Now, if I'm walking the halls of City Hall and I'm I'm perfectly normal, which I should be as far as I don't cause trouble, and I'm not exhibiting any examples of trouble, I may have warrant now, but that's a different point. I'm just talking about being a nut, being crazy about this stuff. I'm not that. I'm walking down the hall of the secure place, the sensitive place. Why couldn't I, being I'm presumed innocent and of good mind, why couldn't I have and keep a concealed weapon, so-called a concealed arm? More importantly, weapon is a commercialized firearm, commercialized again to be regulable. It's not. What you have is an arm, not your leg, but your arm. And so, if I'm in a so-called sensitive place, it's not a limitation to me as a man, in a courthouse, which right now you walk in there, you'll be arrested. If I'm in a sensitive place, given I have the right to arrest felony, wherever I see it. Are you anticipating something, folks? Are you thinking? Are you really listening to what I'm saying? Are you there already? Given I have the duty, again, I'll say even stronger, to arrest felony. And felony arrest may take the use of the most force I can find at the time. Aren't they encroaching upon my right to arrest a government official in the sensitive place? Isn't that one more right they're taking away from me and encroaching on not just the right to bear arms and for the purposes and beyond and antecedent, but also my right to keep order, the public order, by arresting felons in office, if I need to. Now, there's a use of force continuum. You got to be very cognizant of that. We'll cover that. But isn't that just one more thing that we go, to my mind, nobody even talks about these things. Why do you what things that you have an obligation and duty as a so-called citizen? You do that out of your right. I talk to the miners and talk to the landowners. You have someone committing a felony against you in a seated decision, and the sheriff doesn't want to keep the peace and arrest it. You have the right to do it. If you know it's a felony, as I can show you that it is very quickly, and I found a couple more actually. I don't know if the legislature changed it and upped a couple, but I found two more that I didn't see before. I thought I found them all. I think they've changed it. There's two more felonies that I know that exist when a government goes bad. If I'm going to arrest that because the sheriff won't, he's derelict or she is derelict and delinquent in their duty, I have a duty to arrest the felony. That's a felony arrest. I can kill somebody if I need to stop that one from continuing the felony. This case will encroach upon that. For all y'all that are in the States, I don't know about the district residents, but you men and women, wherever you are, your antecedent power comes in. Your citizen rights come pursuant to the Constitution that these folks in government were supposed to limit their authority to. Seems to me, under color of authority, the Supreme Court that omitted to take a case that protected someone's right to carry concealed in his town, or these people that are making the question and limit upon what they could regulate, are all committing felonies by covering the right that they don't have a warrant in law to question. All these folks, that I ought to, the law does not preclude me, no decision they can make to protect themselves from this says that I don't have the right to walk in with an arm to go make a felony arrest against even these judges. Now, again, I'm not advising this. You know what's going to happen. That's just telling you how far away from actual law we are and the immediate accountability for these transgressions against us and why they continue. Please don't think I'm saying I'm going to go down and do that like I'm some force to be reckoned with. I could be, but I'm a realist. I already know what's going to happen. We can't even get the sheriff to actually agree on a policy consideration. What a lawful citizen's arrest would be for you all. And I doubt that many of you have even asked, but those of you have, you probably find it a hesitation at least. They want to put a commercial constraint, that's another violation, but then they want to make a decision under the color of authority of a judiciary, having no authority, no competence, no jurisdiction or authority to decide the limitation on shall, keep, and bear, and yet they are, and they're affecting obligations and duties that you have when you go and say, I have that right, but my right is antecedent. The matured right, which all of us have against the government itself, had to be underneath the government. Underneath that the establishment. The maturity and awareness now says, I could have it outside of that government. And guess what happens with the miners? If you don't go back in history and find the foundations of what happened right, people died, folks, but it happened right. That just shows how bad things are. We have a fallen nature. We don't see reason ahead of time. We have this problem. We need to be beat into submission, or I lose a few of our friends in the process in order to have that come right. That's not keeping the peace. And so I think we have a big awareness shift that has to happen to start making that bar a lot higher. But we're not going to be able to do that as long as we let the excrement that has risen to the top to make decisions like this rule. The caucustocracy has taken away all what you thought was yours, and you continued to be crickets to it. You know, the Wild West, it was said, everyone had a gun, and it was a real respectable place at that point. It was only those that thought that they were aggrandizing themselves through being able to kill lesser capable people. Well, I was the gunslinger, so I made the law. Well, up until he found someone that he couldn't be faster than, or the group that got together under the authority of the sheriff to go stop the aggressor. That was all based in laws, folks. That was all based in agreements. You just don't do that, and because you're not supposed to do that. You don't have an excuse that you shouldn't have known, and you just shouldn't have been hurting people anyway. And now we have right in ourselves to say, amongst us, I would have to do things that I may not normally want to do, but that I'm not charged in doing that against you because you're the aggressor for doing it and protecting myself. And I'm talking about killing that one. I wouldn't want to do it, but if it's me against him and I am not doing anything wrong and I've got the right to defend myself, that's what I have to do. That's the responsibility. I think that's the biggest, biggest cloud, the unseen cloud that struck me long time ago about possessing an arm. I keep wanting to say firearm, but they're not. You have to know that. You have to know that that's not what they are. Firearms are very particular things, and they might be regulable, but they're not everything. And they're just a few utensils that the government's defined. But the biggest cloud that came over for a long time was coming to terms with the fact that the arm is used really only for one thing, and that's to me a very somber thing. You have to realize what you're going to do when you're utilizing that correctly. That appliance, the self-protection appliance, is a really, to me, it became a very solemn problem to come to terms with. It took about 6 months before I did. It took a long time. I was surprised. I was surprised that I didn't see, we can carry, I'm macho maybe. I wasn't even macho. I never had that idea. But I mean, look at me. I can have a gun, right? But the ramifications of the responsibility of that came pretty clear almost immediately, and it come from blindside. It took about 6 months to actually work that through, till the time I finally realized that's what this thing does. And that thing is there because we're not so nice to ourselves, and I can't stop that. I can try to be nice. I can pose my own best example about how to so-called be nice. I can just be as good as I can, but there's going to be people like Genghis Khan that don't like that. They want my stuff. They want to hurt my friends. They want to hurt me. And they want to do it without the real warrant that they need. And so we have this thing, this reality. We might want to do more peaceful things, but we're not. And so that at some point in reality, an escalation of problems comes up and you have to have the tool for the job. And I just wanted to point out, not that I'm going into the Second Amendment so much, although I've now spent the hour on this, and I was supposed to go down the tabs a lot quicker. I think it's important to understand what's being stolen from us is more than just a couple of things that they talk about and these lawyers talk about to diminish our capacity to understand. I keep saying that, I should really change that. Given I have the duty to arrest the felonies I witness, and that requires the use of force sufficient to arrest someone who may come against me with a weapon now, and it might be the armed government agent themselves. There is no place that's sensitive enough that any government official has any right to talk against my right and duty to arrest that felony. And I'm not arresting him just because it's something cool to do. I'm doing it because if you don't arrest the felony, that felon goes out to hurt someone else. That's why you have that rule. In some places, I understand, you become an accessory to the felony if you don't. And I think that might be a good rule. That's the article, I tell you, like for the government, it's 18 U.S.C. 3. You know, as an official having the duty to stop this, if I tell you and you don't, you become the accessory. So it's already in the United States law. But see, there's no real accountability. There's no understanding. There's no the system itself will look at you and say that you're some extremist. To actually believe that you can fulfill your duty to arrest a felony that I'm committing as a government agent? Boy, have they got us duped or what, folks? And they do it through these kind of court cases. The way this is being set up, if the Supreme Court takes it, I'm not so sure that the proper meanderings are going to be sufficient to expose. There is no limit on shall, keep, and bear. In other words, there's no regulable limit on how you bear or where, given other rights that you have, one outside antecedent and one inside the establishment, the duty of a citizen to arrest the crime against you. So I hope there's a little insight there. There's others. I didn't want to go too deep on all this. You go on and on about all what you're interfered with. You got to start taking the short notes on what those make the bullet points about all those things that are being interfered with when they do this kind of thing. That say, well, you didn't consider all of this. You considered the 14th century, but forgot you now interfere with my right to make a felony arrest anywhere I might witness it. And other things. I mean, there's all kinds of things. Doesn't have to be in a sensitive place anyway. So some of the problem within the Supreme Court was intimated by Justice Thomas. Justice Thomas calls out the Supreme Court for not believing in the Second Amendment. And so this is an interesting insight, I thought, given he says that. This is where you see the Bar Association is really just this administrative, like human rights. Your rights are subject to the state. The do-gooders in high places, the elites who have the decision, have taken the decision because you handed it to them. And they don't believe in the Second Amendment. Well, I wouldn't. I can tell you that. Why would they do that when they have a believe and they support the government, the NGO, the Bar Association? The NGO supports the United Nations that would tie a knot in the barrel of your pistola. Supreme Court Justice Clarence Thomas had stern words for his colleagues when the court declined to hear a case challenging California's handgun laws, saying that the jurists do not understand the importance of self-defense. The case supported by the National Rifle Association, and those folks, get out of that one. These people are just no good. They're not doing these things that I'm telling you to do, and I really don't look at the Second Amendment too much. It's when it comes up and I see these stories and I see how they're deceiving us in bigger ways. That's the only reason why I talk about it. But these associations, again, are legal entities. And they are destroying and they only can work through attorneys, too, if you haven't figured that out. This is the power of the mining district. It doesn't have to work through any attorneys. It can't. And it would throw them out anyway. Historically, tradition and custom is to run an attorney out of a mining camp on a rail, and he'd be lucky if you did that. But this Supreme Court doesn't believe in the Second Amendment. That's not enforcing the law. And so you're seeing an insight in this statement, beyond what even the discussion that Clarence Thomas may even provide, that why this case is going into that Supreme Court is a much of a problem. It's as much as a problem going in with a potential to say to conceal outside, to carry outside is a right. They still haven't got to the point that where do you limit shall keep and bear doesn't have a limit. He goes, the case supported by the National Rifle Association involves a San Diego resident, San Diego resident. How about just a man? See, this is how they get you. Edward, and they may not even they won't recognize. As soon as you tell them you get the evidence, you're a man, the court's going to say, as I told you the story, about my friend going in, I told him to do this so that we could prove this out. And the court, when the cop said, yeah, he's a man, the court interfered and said, tampered with the evidence and said, if I allowed that testimony that you're a man in the court record, we couldn't prosecute anybody. Anyone. I don't know what the exact word. I would assume he would have said anyone. There's a distinction. Any body is the legal bodies. Anyone is a man and woman. Yeah, so anyone. He couldn't do it. So we realized, that was known before. That's why we did that pursuit. A resident is a legal entity. It's underneath this statutory control, and it itself requires permissions because it's born in that state, not you're as a man or a woman. It's just a legal entity, and they all need lawyers. They all need attorneys promoting the profession, aren't they? So Eduardo Peruta, who challenged his county's refusal to grant him a permission to carry a concealed firearm outside of his home. What about an arm? And why wouldn't the sheriff be gotten underneath the law for interfering with his right as a felony? Because they say the county, but it's the sheriff, and I think that they're an individual office. For those of us who work in marbled halls guarded constantly by vigilant and dedicated police force, military force, folks, and this should be another thing I haven't talked about. I talk about all the time, but not here. The dedicated military force. It should be governed. I mean, that's the reason it's there. When they went military force, that required you have to bear arms, and you could keep them anywhere you wanted. But no one talks about this one. The guarantees of the Second Amendment might seem antiquated and superfluous. Guarantees, folks? Guarantees? Clarence Thomas believes they're guarantees. Well, they have a guarantor. Well, that was you. And then you got an interferer, and that was the government. Thomas wrote that you have guarantees. And how are guarantees antiquated and superfluous is another problem. These non-believers in the Supreme Court quote, but the framers made a clear choice. They reserved to all Americans the right to bear arms for self-defense. I do not think we should stand by idly while a state denies its citizens the right, particularly when their very lives depend on it. We'll go on more. We can read more and more. I'm running on and on here on time, but it's not just self-defense again, but that's what they keep focusing on. So as much as there's guarantees, he doesn't talk about them in a comprehensive way. The Second Amendment wasn't for self-defense. That was antecedent the existence of the government. That was understood you had it by that time. Then it matured. And it matured into knowing, well, we can extend that over. We can actually go after the king with our sticks and stones. Our pea shooters. We can actually now address the government itself. The king isn't no high and mighty thing. So much for political sovereignty, isn't it? But we forget all this stuff. And what about your so-called citizen obligation and duty to arrest the felonies you witness? How are you going to do that when you're in a sensitive place? And everybody you witness is committing felonies, and they're all part of the organized criminal conspiracy. Isn't that right? Your duty now, it's an obligation and duty. That's something a little bit different, is infringed. Are they going to come out and say, oh, well, we are presumed to do innocent when you witness and have probable cause to believe counter? There's not much of an answer for that side to say, unless you don't state it. And then they don't have to. And if you got what I was saying before, every passage they had the opportunity, they did not expand on how comprehensive the Second Amendment touches in its mature, not just as an antecedent position, Before the government, antecedent, before the government, existence, establishment, but after. It's matured by that statement, amendment, a year after the Constitution establishes government. So, watch very carefully how these go. I'm more concerned not what they say, but how they're taking it, incrementally taking away everything you understood or thought you understood. Those of you that are older, those of you that are younger probably don't care, and that you'll find the error of that way pretty soon enough. You're probably not tuned in, but maybe in the future, maybe some archive somewhere will still be around that I'm talking, and you'll say, well, that guy was kind of nuts that time, but it's making a lot of sense right now. But I don't know. I'm not, like I said, they're changing you chemically, environmentally, epigenetically. You may not know. You may not be able to. And if they get to you genetically, watch out. Forget it. Forget it. So I'll move on to another thing. I talked about the land law, the law of the land, the land disposal laws that you can find are required in every state, and why some of these questions become nonsensical to me. But something came down and very important to all y'all, actually, whether you actually realize this, even those that live in the city or just outside in so-called urban areas, maybe don't even get off in the public land to go visit it. But there's a very big war going on with the conservative, the progressive, the social justice, the sustainable development, hug the frogs and bunnies more importantly than your existing in the world in any kind of improving fashion. And again, I say that because there's more and more evidence finally coming out. Kind of like when Trump questioned climate change, everyone who had a better knowledge about this finally had the ability to stand up, or the backbone to stand up and talk about how corrupt it is, and the crime it is, the fraud and felony it is. Sometimes takes that to get people to speak. It's now finding out that people, men and women going out in the land and developing it, are actually much better for the environment in a total than not, and letting it run wild. But not short of that, just the access of the disposal, the land, as I said, the miners went out and were mining, and they were outlawed until the mining law of 1866 happened. Then they were legalized, I guess, lawfulized, because it's actually lawful because it's a grant of land. It's not just a regulation. The law, as a grantor, granted under its obligation, it granted public land for lawful uses. One of those, when you get land, and this is the thing that people start missing, I think, a lot of appurtenant rights must come with land. If you have land, you have to have a way to get there. And so an appurtenant right, even if it wasn't mentioned in the Act of 1866, as I mentioned before, the road, the access, the ingress and egress would have had to come appurtenant the right of the grant of the land, and that comes underneath another type of supporting provision called the prohibition against land blocking. You don't land block a parcel of land out of access to it. There's provisions that when that happens, that the surrounding properties will either decide how to make ingress and egress among themselves, or a court can come in underneath the rules and neutrally come in and make that designation for them, so that you don't ever someone lock them out of their property by access on the land. So access, ingress and egress, is really important. It's pertinent. But Congress did something very interesting. They didn't leave it as a question. In 1866, along with the minerals and the patents and the water they granted at Section 9, they granted the construction of highways at Section 8. That later was codified, from 1866, codified later on, maybe in the 1880s or so sometime, to revise statute 2477. And your highways, here again, the highway law is different than the motor vehicle code. Motor vehicle code's in commerce. The highway disposal is in your organic documents and the obligations and duties of government. The government isn't a sovereign there. The government is a trustee there, and it's to protect it. And so an important case just came up that I want you to know about, and I posted this at minds.com too, a little bit, because a lot of people should be interested in how this rolls out. This is the same problem as the gun issue. They gave a more right answer, but they did it on the attorney's assertions And they did it through an improper method. So I'm going to show you, read through a little bit of this to set this up, but I'm going to explain to you how the Supreme Court of Utah is wrong, how the Attorney General of Utah is wrong, how the court identifies the Grand Green terrorists and their attorneys as nonsensical. Now, it finally came out, and that there's a misperception about what RS 2477 ends up working out till today about. Everyone wants to make this about this codified road subject matter. In fact, it's coming from a prior grant in 1866. And I go back to the grant, not the codification. And we go back to that because our rights relate back to the date of a grant, not the codification. And this is all just grant law. And if you just read enough and maybe get on the Jefferson Mining District website, we have documents. You go to read through. One of them, I think, is in the bag of law. It's the supplemental. I think you'll find a passage or two that speaks to this relation back doctrine. Very important stuff to keep in your mind. A relation back before the existence of the government is your right to keep and bear arms for your self-defense. You don't hear any of that in that discussion. And in this case, on the highways, you hear some very interesting problems. Well, I do. Maybe most of y'all, maybe not, but they're there. And I'll try to cut through here real quick about that. High Court calls road claim completely nonsensical. And this was just a beatdown by the Supreme Court of Utah over their attorneys, how they could actually have advanced the cause of the environmentalists, saying that Utah no longer had abandoned and forfeited its right to claim so-called RS 2477 roads. In a pivotal ruling in Utah's legal battle, to control thousands of routes. This is another adulteration going on. You don't know this if you don't read enough things about the Forest Service and the BLM and how they've changed things to routing and routes. Routes are commerce. We're not dealing in it. But notwithstanding, see, I read this, folks. I don't know I read this totally different. When I'm reading this, I'm just reading to you, and I'm looking at these words, and I'm not even telling you half of what I'm watching. But certain things pop up. This is one of them. This is why I wish if you had the black and white in your eyes, you could make these decisions without question, as quick as I do. And we could be moving along. We would start living underneath the peace again that these laws provide to us. We wouldn't be abandoning them. We wouldn't be attacking them. We wouldn't even attack the government generally. We would be finding the people that are the felons, essentially the felons that are interfering. I say interfering. Why do I say the word interfering? Because in the enabling acts, if you look around at your enabling acts, the document that created the state that you live in, you'll probably find a provision that said that state cedes the lands, the public lands, to the government. And that purpose was to remove all future claim of the state over the land that would be future disposed, and puts on the federal government the obligation and duty to redispose to people in the state that was just created, that was a territory. And there's a cession of land to the United States government that's called public land that's supposed to come back to the people in an orderly disposal that the state shall never interfere with. A disposal the state shall never interfere with. So we had private claims could be made, or we have what we call, I tell you the usufruct, the real technical name, the common use. This is the people's use, the public use. Even legal entities can use this. The public use of this land disposed to the use of the highway is what Section 8 of the 1866 Act speaks to when it says the right to construct the highways is hereby granted. Period. No limitations. It's even as clean as the Second Amendment. No limitations. You shall have the right to bear and keep and bear arms. The right to construct the highways is hereby granted. That's it. No limitation. For lawful purposes, obviously. Now, that's the law. Our relation back to that is what we stand on. It's not RS 2477 to begin with. This case is a ruling. It's a pivotal ruling. I have a problem with this, but a pivotal ruling in Utah's legal battle to control thousands of routes crossing federal land. A divided Utah Supreme Court has held that these road claims have not run out of time under an obscure state law. And that was the Southern Utah Wilderness Alliance's assertion through their attorneys, that the state's time has run out to claim those roads, joined by the Southern Utah Wilderness Alliance federal lawyers. Folks, this is what we're up against at the federal level with the miners. We've got federal lawyers that are doing this to the miners. This is all you're seeing. Almost the whole point here as well. Federal lawyers had argued the statute in question barred, quote, quiet title claims after 7 years, meaning the Utah's claim to more than 12,000 routes covering 35,000 miles would have been extinguished as long ago as 1983. And I just got an answer. I was looking because I didn't know if Utah had a statutory acceptance, and I just now saw that they just claimed that that's what it is. And they've inverted how it works, just like a bar member would do it when you're trying to steal back land. Federal lawyers had argued the statute in question barred quiet title claims after 7 years. Now, I haven't seen the Utah statutory acceptance, but that's the time right there, folks. That's the time when they say, well, after 7 years, you can't make the claim. No, that's not what the statute says. Those statutes are very simple. If you jump on over to Jefferson Mining District, go down to the Bag of Law section right near the top and download the PDF for the Highways and Trails, the Highways document. Just click on the button. You'll see where there's a statutory acceptance for Oregon, and it says essentially the same thing, but its statutory acceptance is 10 years. And what it says is that a road that exists for 10 years unprotested is deemed is deemed a county road. Now, they changed that in 1981 to public road, and that's why I made the mistake. After 1981, it's a public road, but it's the entirety of the road. So after a road exists for 10 years, the statutory acceptance of that grant is that in 10 years unprotested, it becomes a public road. It's no longer RS 2477. It's no longer a question. It's now under county control. In most states I've read, it's a thing of county concern, and exclusively so. They're not RS 2477, and they're disposed. Therefore, the first statement by the federal attorneys that the statute in question barred quiet title claims is actually correct, but it's not reasoned by the limitation of 7 years. It's because it's not a quiet title question. It's by law. As a matter of law, it's disposed to state, common people, public authority to use, and it's determined to be a thing of county concern over the modifications of those disposed forever rights of way, if I can call them that way, highways and down to the trail. There's a whole different analysis. The quiet title claims are barred because as a matter of law that hasn't been overturned as unconstitutional or in violation or contrary to the laws of the United States for disposal. The quiet title action is barred because of the statutory acceptance of 7 years, that it changes and becomes the state, common people's, the public use, and disposed away from federal control and into state or county oversight, trusteeship. The grant, acceptance of the grant of which can never be interfered with by the parties who made it. That's you and I and our ancestors who made and constructed those roads for all lawful purposes. And that's why the miners have the very big power here, because that's how almost all these roads were made, a lot of them. And our rights relate back to those miners making those roads. And they are perfected at the time of, in this case, in Utah, 7 years they actually were disposed to that use and now placed in state authority. That's why you don't have to have a law for state lands, a public lands transfer. It's all nonsense. But let's move on. I keep getting to interject. There's so much to talk about, folks. It's so much clearer and so much less convoluted than the Utah Supreme Court made and the attorneys made and the federal lawyers. You see, they're criminals that tell this half story and then try to shut you out of the rest of it, is what federal government's doing. That's a trust breach. Those lawyers should be going to jail. They are felons, folks. They took a color of authority and they asserted a contrary right, causing the state to have to defend itself. Even though they were doing the quiet title action wrongly. The attorney in the Utah attorney is doing it wrong. He didn't accept the highway as state law did underneath their statutory acceptance law, which happened, they all seem to happen around the 1900s. I don't have all the numbers memorized. I think Washington is 5 years or something, 7 years. Oregon, 10 years. Idaho, I think, is 7. Nevada, I think, might be 5. California, I think, is 7. Oregon actually has 3 more years extension on that. But that's the time that after 1976, everything, at least until the states challenge the retention policy. It's only a policy. It's not law. It's a violation and breach of the roads. Every road is not an RS 2477. They're all disposed into public use. That's how absurd this actually gets. But the federal government actually asserts, and the Gang Green asserts, a nonsensical imposition. Justice Chief Matthew Durant wrote that such a result would be absurd and deviate from whatever lawmakers intended when they passed the relevant law known as a statute of repose. Well, they could put these funny titles, statute of repose, folks. This is a grant. Yeah, it just sits there waiting to be fulfilled. Call it all these fancy words and not say nothing, folks, or you can just bring it right up and say what it is. The United States argument, quote, would effectively deprive the states of its, quote, close quote, claims to thousands of routes, including some that may be existed and been used for decades. Durant wrote in the ruling handed down Thursday, why don't they refer to the statutory acceptance? The fact of its existence for decades perfected its disposal to the state. To y'all is what it is. Forget the state. The y'all is the state. It's the public now. It's not the government. It's the people. And it happens to be those legal entities that would use that for lawful purposes. That could be commerce. But effectively, the underlying grant is what I'm talking about here, that the state of Utah Supreme Court will not tell you about and will actually not acknowledge. The fact that the road existed for more than a decade or more decades proved it was disposed. That's how it's absurd. But you don't hear that in his statement, do you? The United States arguments, quote, would effectively deprive the states of its claims. It's not the claims of the state. The property is disposed to the use of the people, folks. Another error. If I may be so bold to repeatedly say they don't know what they're talking about here, and that I think I do. So, are you a lawyer? Yeah. No, I sued the lawyers and found out they admitted to me they commit treason by default. Just get on Justia, type in Jefferson Mining, or type in Jefferson Mining District in Justia, or Jefferson Mining District in Kitzhopper, and look at that and then realize you can't get the files on that, folks. You're not going to get the file. We can't even get the files on that. They don't want you to see this stuff. I'm not talking just to be talking and hear myself talk. We're in such trouble because we don't understand the most basic things, and we let these attorneys at whatever level make discussion it's nonsensical from my standpoint. I'll put it that way. That's nonsensical. It's not just absurd, it's nonsensical to not have a Supreme Court delineate what and how this thing works. A statutory acceptance has not been found to be contrary to the intention of Congress to accept the grant of the construction of the highways for public use. No restrictions, folks. No regulation. It's the use, all lawful use. Every obstruction of which is a crime against that as well. That's the implied thing that comes along with that, where there's no implication on the grant. That's the implied one of them. The High Court called such a result completely nonsensical and so overwhelmingly absurd, this is in quotes now, so folks, so overwhelmingly absurd that no rational legislator could ever be deemed to have supported. This is a slapdown of monumental capacity, and this is a slapdown that's been done in wrong. It's right, but it's wrong. They have a right to slap it down, but they didn't go far enough themselves. I'm slapping them down. We're behind the woodshed, folks. This is not that hard. It's right in our face how they're taking us out, how they incrementally move the bar of control up as they stop actually putting the precepts of law down. Utah Attorney General Sean D. Reyes applauded the ruling, calling it a common sense decision. What have I told you about this common sense nonsense? There is no such thing as common sense in land disposal, folks. Just not. It's the way the land disposes and to whom, for what reason. The highways go to everyone and everybody. And I make a distinction. I made it before. I guess I hope you can hear the fundamental foundation of law working. Whether you talk about the Second Amendment, I'm using pretty much the same words when I'm looking at grants and disposals of land. The law of the land is not changeable by these folks. They'll try to change it. They'll try to reframe it. They'll try to get you to not know what the underlying points are. They won't even tell you this stuff. You don't hear any of it. That you're hearing me tell you that when you go read the document, and I see Cowboy Tech put that in the RLM chat, thank you, the PDF, Highways and Trails, just read through that. I know it's only for Oregon, but it's consistent in all the West. And then remember, full faith and credit and completely equal treatment back east, it all starts to tie together when you start understanding this. One thing is, it's a highway and trail, not an RS 2477. Let me repeat so you don't lose this. Why? Because the state made a constitutional statute that accepted the grant or the construction of anyone for lawful purposes as a public highway in the state. Not the state they're regulating now, in the granted state. And the obligation and duty of Congress to fulfill its grant to the people of the state in the Admissions Acts of 1859 to give them back utility and purpose and production and wealth, but in a way that was free and clear of all state government interference and with reserve in the law. Reservations. I mean, I talk faster, but I mean, it's all there, folks. So did I talk maybe too fast? I don't get any comments back to me. It's really kind of frustrating. If you're understanding what I said, can we move on? I mean, can we get people to start helping out? To me, this whole thing is dragging on because we're listening to everybody else to be the documentarians out there instead of the ones that are defending ourselves with the law. I don't have to argue anybody. I don't need a gun, folks. It's rapid fire behind the woodshed, but it's not using a gun. I don't need a quiet title action. I can guarantee that. We just went through that this week. It all came kind of close together, too. In fact, I used this case to show my colleagues how they did it wrong, and we were able to convey that to county commissioners. They saw it, too, once they understood the foundation. They get this. A few people are getting this in the seats of decision, folks. And we don't need lawyers, and we don't need the courts, and we don't need an opinion, and we don't need authority. I don't need a gun either. I just need a lot of people understanding what I've been trying to say. I've been saying it. What I want you to understand about it, how you can see it yourself, and then how you implement that around you. I'm only focusing on these certain subject matter areas. The way this works, it spans itself like that ripple in a pond. It all affects the same body in the same subject matter context. All the same. Even for as different as it sounds like it is, it's all the same. It's only interfered with by these environmental types, like these urban-rural types, like these sustainable development types, like the bar members themselves, all these associations that want to be do-gooders. They're all just legal entities. They don't have the power of a man and a woman when you start looking at the land that's supposed to be disposed to certain lawful people, men and women, unless there's a public need. And that's when you see the railroads getting some of this land. And when they didn't do it right, it got returned. The grantor came and said, you breached the grant, I'm returning it. That's you find that in Oregon, too, the Oregon and California railroad lands. And they eventually had to give back the minerals to the people again. So you can go back into there to get those minerals. This is how foundational this law is I'm talking about. The Congress and the states can't interfere. It's in their agreement. And that agreement cannot be changed. The parties can't go in and change those admission acts. They are set in stone. And it says it shall not interfere with the disposal. The states accepted that grant after so much time. That's agreed to. They are no longer RS 2477 roads that require a question, a quiet title question to be answered by a third-party bar member. Am I getting excited? I think I am. Get excited about this, folks. I'm adamant about the fact of this, and I'm sure about it. And I figure, I guess, if I get adamant, you'll believe me more, I suppose. The court correctly recognized the absurdity of the federal government's argument, which have now added 2 years of delay and taxpayer expense to the state's efforts to obtain title to the roads that federal law has long promised. I hope the court's decision convinces the United States now to work collaboratively and quickly with Utah and its counties to resolve these title claims. Folks, collaboratively we sued to enjoin as a felony against the people. So they're going to hand this back to a bunch of stakeholders to interfere with, first of all. Secondly, he doesn't have to go in and resolve these. They're resolved as a matter of law. Why don't these people understand this? It's resolved as I just explained it, so I won't repeat myself because I was going to go off and do it again. Like if I repeat myself enough, you're going to get it, those of you listening. The state's efforts to obtain title. The state doesn't get title, folks. Let's get that straight. The people in usufruct, and I didn't cuss, in usufruct, get title. It's in common, not common sense. It's in common, the common use. Use is a trust. The word use is a trust establishment. The state gets obligations and duty to protect it. The states typically assigned that, delegated that responsibility to the counties who cannot interfere with this underlying grant. I'm getting excited again. This is such a powerful, powerful understanding and tool. I wish you all would really just get it and be able to articulate it and go walk in and just educate your commissioners about how this works so that they don't have to waste time. And there is no additional expense. What have I told you? These federal impositions and these wrongful attorney impositions cause and misappropriate monies from the Treasury. However fictional that is, it's still something that they use to demarcate. It's taken from property owners, I think unlawful as well, but it's taken from this very people that they weren't supposed to interfere with. Another problem. And we're crickets to every bit of it. And I'm not going to calm down, am I? I'm getting into this. I want to be calm. I can't do it. There's a lot of energy behind this law. It's power, folks. You have it. It's yours. It's not in even what the Supreme Court's saying. I'm behind the woodshed. I'm taking the switch after the Utah Supreme Court. They didn't do it right, though they came to the right conclusion that it's not in the federal government, and it's nonsensical what the federal attorneys will do to you. It doesn't stop at the roads. The 7 miners issue was the same thing. We came back at them so hard. You haven't heard of any more 7 more miners getting blasted by the federal government because we hit them so hard. We couldn't fix the system. It's corrupt. But we hit them so hard that they were, I think, embarrassed to realize there was actually knowledge out there to catch them violating people. And if I had 4,000 miners that I was hoping we could get, this problem would have been over maybe a year or 2 years ago. But no, we can't get people together to fight for themselves in the right way. No, we've got to have our own opinions. We've got to talk about the grant but not know how to impose it. We've got to talk about the grant, then go and get an attorney in order to help us get another attorney to decide that it's what we needed. This is not about a state's title. This is about the title that sits in the public, the people, that is protected as a trust arrangement between Congress and the ceding back to the state under the state agreeing as a government establishment to do so in the Admissions Act, or what you call the enabling acts for other states, all the western states. Now, the story goes on and on. What else do I see? The Voros noted that the allegedly absurd result actually reflects prevailing national law nationwide for the passage of the Mining Act of 1866 until the passage of the Quiet Title Act of 1972. That's not true. The Mining Act is all by itself. It was amended and modified in 1870 and then 1872, and it hasn't been amended and expanded anymore. It wasn't, notwithstanding what all other miners might say, oh, well, the 1955 Act conditioned it. No, it didn't. Go read the CFRs. The CFRs will tell you that the 1955 Act amended the 1947 Common Mineral Materials, and even so, we've got 2 IBLA memorandums that say that the rights of the mill sites and those that come after 55 still have their ingress and egress rights and their timber rights, just like the uncommon minerals of 1872, the valuable mineral deposits. Everything has its own rights, folks, or not, and you got to be able to identify it. Every one of those shall have ingress and egress And it's all under the relation-backed doctrine to you shall construct the highways for the purposes of what, folks? Watershed production, it turns out. The very same thing that the eco-terrorists will argue they're protecting, they're destroying. They don't want you to have wealth. That's where this stuff... I was looking at something... I can't remember now where it was. I think it was a little video seeing about economics. I didn't even get into too much of it, got too much time. I wish I could remember this a little bit. But they're talking about economics is on a rationale. It's on a logic. Folks, economics can't account for a baby calf being born out of a cow that comes from the land. They can't do it. That's where your law is, right there, in their unaccountability. And they weren't supposed to interfere. I got excited again, didn't I? Yelling and screaming. This is exciting stuff, I guess, somehow, folks. And it's not exciting. It's really kind of it's ruined my life. The problem is that none of y'all have been stepping up with this excitement to put down those that oppress us. And we allow these kinds of cases to come down and talk about, oh, there's a quiet title action. The title is in question. No, it is a matter of law, pursuant apparently to Utah's statutory acceptance of 7 years. When those things were 7 years old, they all, as a matter of law, were disposed to the state in trust for the you all to do good and lawful things. Produce for yourself. Be productive. And that's where the wealth. See, the wealth is the Mother Nature adding the calf to the cow that they can't account for. And you were husbandman enough in order to coax Mother Nature to do. And you went out in the timber and you cut down all the extra that was not needed by the forest that would cause fire, and you kept the forest at class 1. In the meantime, because of the way it's been working out, your local county got a percentage of that to pay its bills. So then you take down the burden because of your productive use. That what grew from Mother Nature you managed wisely, and you harvested and improved that harvest in order for the community to bear the benefit as well. And you got yours. All from Mother Nature. You did that. You don't do that, it goes and it burns. And you get the government doing it, and it goes bad. And that's a big trust breach felony in the whole thing. But there is no quiet title action applicable to this matter of law disposal underneath the enabling acts of any state, at least West. Most of the East has already been done, so I don't know about all that. And I'm not talking, they talk about it here, Thursday's ruling allows lawyers to get back to the arduous task of litigating the validity of the state's roads claims that have been stewing in the United States court since 2011. Now, this is the other point I forgot I have to make. On that very point, the last paragraph. The state must demonstrate each road was open for public travel for 10 continuous years prior to 1976, when the Federal Land Management and Policy Act was established, repealing RS 2477. Big problems here. First of all, since it's operation of law disposal, why are the lawyers going to be given the arduous task to litigate this continuing wound when all that's going to do actually is put cha-ching into the attorney's pockets and not fulfill the law and prolong the agony to the Bar Association's professions organization? And the state must demonstrate each road was open for a public travel for 10 years. What determined that time? Maybe my 7-year analysis before is incorrect, and their statutory acceptance is actually 10 years. It doesn't matter. After 10 years, it, as a matter of law, disposed that land for public use to the highway it was constructed to on relation back to the 1866 Act. There, I said it again. Nice little 15 seconds to show that they're all wrong here, and it shouldn't be, but immediately that this changes over. Now, I've got 2 links. One, it says the nonsensical. The second link I have, it talks about the victory. It wasn't a victory in the straight up manner. This is all convoluted. It's a victory if you look at it my way and fix it the way I'm saying. MarkOnTheBeastYahoo.com. Anybody have a contrary view, you better bring it. If you think so, and you think that the government has this thing in the bag and that the judges know what they're talking about, I want to see your proof. It doesn't make sense to me. The second article says in recent years, aggressive green groups, I call gang green, the federal agencies, including the Bureau of Land Management and U.S. Forest Service, have sparked conflicts over a number of Utah historical county roads, with the most notable case involving the road of the San Juan County's Recapture Canyon. Folks, it's not a conflict. These are all felons interposing their authority over the people's use of the road without warrant. In most states, I think I was just talking to someone in Idaho, it's only a misdemeanor. In other states, it's a felony for these people to do this, using the color of an authority that has no warrant in law to interfere with your rights of ingress and egress all over the public lands that the federal government wasn't supposed to sit. It now change the policy and constrain it to keep it. They were supposed to dispose of it into private use. Why am I not hearing that in these cases? It's because the Bar Association and this conservative mentality is running roughshod over the law that was made for the benefit of you all. It's the productive law. It's what sits underneath how this society actually functions. Minerals being declared public necessity, public benefit, public use. So high is production. Minerals and farming, ingress and egress, given right in Constitution to use. Do you hear much of this at all today, folks? What you hear is more of it as a question when all y'all are going down into court and getting your commerce connection going and being found guilty for using the roads you had right to because you didn't understand there's this big distinction and chasm that's been tried to bridge. Oh, big bridge is over, the common sense bridge that says, oh, you can't do that. You're insecure. We need to keep you from yourself. Where is that written in those highway construction grants, folks? Nowhere. This is what we accept as a diminished mentality people. Dupable. Ignorance isn't even good enough here. We're below that. I'm so bold to say these attorneys don't know what they're talking about. Folks, remember Ken Ivory, the guy who did the solution big enough, who said that the states have to retain the land possession, get title, wanted the solution revolution to change the title. He's out of Utah. He's the one that told us lawyers don't know about this land disposal law. He also agreed to 5 other failures that his presentation had, which he removes later on in the year when he went somewhere else because he didn't want people to see what they're doing wrong. No, it didn't take a lawyer to figure that out. It took a dumb miner. The same miner that wrote the law in 1866, accepted by Congress. It wasn't guns, folks. It wasn't lawyers. It wasn't the legislators. It wasn't anybody. It was a group of people. Finally, the court said, hey, you can't beat on these people for something you were forbearing for them to do, and you have the obligation and duty to do anyway. Oh, and then they come to toe. Oh, they're going to make a law. And all they said was, okay, you miners have it all figured out. We're going to recognize your mining districts and your custom and tradition, and go ahead, have at it. We won't keep trying to kill you with our army. Well, that brought peace, folks. The same peace the sheriff is supposed to keep. And we have property rights, which is what the peace that's being kept. Your ability to go to your property and produce from it. The right of ingress, the right to water where you can get it. The right where you can get together with people to get more water if you don't have it. It's just you getting together with yourselves under objective laws so that no one can get around anybody that we keep throwing out. Oh, that's not no good. Oh, the government's so bad. Well, the government's not supposed to be an active force unless it's trying to arrest a criminal. And it wasn't supposed to become the criminal itself. And when it did, and you went crickets, it won. And yet the law actually operating as a matter of law is so much faster. Do I go on? One more property rights. Is, we keep the peace, we keep the property. Well, the Supreme Court limits rights on property owners. Another type of story. And this is where I was going to go a whole bunch of these things where there's encroachments now by the Supreme Court. As they got it wrong in Utah, they're going to come after some other things based in zoning. But guess what? That means that the attorneys subverted these people's property. and they brought it under zoning regulations. What did I say, folks? The state had no overriding and disposed of their rights in the Admissions Act or your Enabling Acts. They had no right to come back later to impose anything that was not reserved in the cession of the land and then the redisposal to you. And yet people agree that there's supposed to be a zoning regulation on their land. Folks, we just got another county a county to fully recognize, and their assessor's office is going to go this winter. We just heard it from the public record. They're working this winter to show and go back and correct all the zoning impositions that were put on these disposals, like mining, that are interfering with it because they're unlawful. Let me impose this RS 2477 nonsensical nonsense quiet title. In that same county, in the same hearing, we have got a group of miners that went to the county where the state, not the federal, but the state Fish and Wildlife put signs to close 65 roads in one area. The state Fish and Wildlife closed 65 roads by signage. Our miners got together, took pictures, got their maps, put the pictures with the maps, went to the county and said, these folks up here at the state are violating the law. You need to fix this. Within 3 days, folks. It didn't take RS 2477, didn't take quiet title, didn't take an attorney one. Didn't even take looking at anybody else with some sort of authority. It took the county, who has the authority, to go inquire through the sheriff, how do you have the right to post these signs as making a constructive obstruction? And that state of Fish and Wildlife, all these eco-terrorists in there, and it must be for the saving of the fish, they said, oh, you saw the signs? Oh, sorry, we didn't know we weren't supposed to put that. We were supposed to work with the county. We understand that. We didn't. That won't happen again. We'll take those signs down. Folks, within 72 hours, we reasserted through our miners and helping and being there to witness the crime. We shouldn't have had to been there, but we were. And we had a county, a body of commissioners that understood the law, that reopened those roads and got the Fish and Wildlife to commit to pull those signs down post-haste. It took 3 days, didn't take the Supreme Court of Utah, didn't take the Supreme Court of Oregon, took no attorneys at all. It takes the law, and it works. It should work faster, and hopefully next time it will work faster, given there's a next time. But, folks, this is a method that didn't take guns, it didn't take destroying the government, it didn't take talking about anarchy, it didn't take talking about, oh, we got to go and do it ourselves. No, it just said, no, the government sits here, the county sits, talk about a state of repose, it sits in repose to protect as a trustee your right to access your public lands, and no other entity has that authority at all. Not even the Supreme Court to make the decision. It's already done. That's what called as a matter of law is. It's disposed to your use. Now you tell me why, when we get a county doing that, and only one's doing it, first of all, that's a problem. Why aren't they all doing it? That we have to now listen to the nonsense coming out of the Utah Supreme Court that's going to cha-ching everybody over there in Utah to open their roads. When as a matter of law, the statutory acceptance perfected that disposal. Folks, it's just right there. I don't know. I feel at peace at some level. If you all knew that and we were all of that knowledge and of that action, I just can't get beyond that we wouldn't be living in such a more peaceful place. That our problems would alter a bit. That they wouldn't be all these things that they keep our time and energy in. There would be no delay for getting people back into. At least now we started encroaching on the BLM. If you didn't have a right to interfere with that, what else don't you have the right to interfere with? That's just as easy to point out, folks. It's just that we don't have enough people discussing it. I talk about it from this aspect because we're talking about the law of the land and what made this country great, and what's going to make it great again is not Trump. It's going to be you. And you're going to make an independent system of production because the system is only commerce and economics. It can't account for the first calf coming out of a cow, which you bring out from nature's gift. This is not in commerce regulation side. I've been saying that over and over. And you'll see the commerce regulation side is the attorneys. I said they were a professions group. The union, that is the attorneys, is a commerce side. Is it tying together, folks? I hope it is tying together. I mean, I know I speak kind of fast. I mean, I know you may even get an image and you're agreeing, but At some point, you really have to slow up, go to the places I'm telling you to look, see it in your eyes. The Highways and Trails document is 4 pages. You only need the first 2 to understand what I've just said. It's written right in there. Let me remind you, these highways, counter to what the Utah Supreme Court just says, and the quiet title, which the lawyer says, the Attorney General says we have to do quiet title actions. No, it says it right in there that these highways are pre-existing claims of possession to the people. Pre-existing claims of possession. Pre-existing claims of possession. Pre-existing what? Pre-existing the government itself. Oh my goodness, antecedent? Are you kidding me? Antecedent is pre-existing claims? Have I rounded us back to the Second Amendment? The Second Amendment is just restating a pre-existing right of possession, enjoyment, use, which I shall keep and bear. The mining law says there's a highway construction that is a pre-existing claim once claimed for the use. It is a pre-existing claim. It's antecedent the existence of the government and the establishment of that as well. Talk about mature here, folks. I almost get chills. And how far we have gone from this simple answer is really astonishing at some level. But I'm going to go one more quick thing. And 1.8 million California acres were set aside for frogs. Ranchers say decision ignores them. If that's the case, and this is the frog thing down in California, yellow-bellied, sap-sucking, spotted, whatever, and I don't have problems against frogs. I talk to them in my garden all the time. I got them all over the place. I water them. I feed them. I watch them. Anyway. Tiny frogs and toads use a swarm of over the Sierra Nevada. That's, I think, a lie because they found out they were only in a couple spots, not even within a couple of miles of each other. We almost wondered that they were planted. Jefferson Mining District made a comment to this. We haven't had the manpower to go and charge against this. The California ranchers and the logging groups are saying that that's hurting them. That this 1.8 million acres has been put underneath this problem. Well, it's also the type of land that they are in is a national, it's like a wilderness or something. The point is that the ranchers and the loggers are being affected, and I'm concerned that they're not going to advance this. The critical habitat established under the Endangered Species Act does not say that they have to be kicked out. What the Endangered Species Act looks at is if you can, where practicable, salvage and save a marketable, commercially viable species, then you do so. Otherwise, there's nothing in the Endangered Species Act that says you have to save an endangered species, one that's going down the tubes, because nature has killed off 99% of all the life form that's ever been on the earth. But if they don't argue the right thing, they're going to lose this. It's the same thing. The attorneys take this. Now, the group that's taken this on, the attorney group, has a good track record, but as I told you, they do the administrative side problem. They don't actually get to the underlying right, and they wouldn't actually necessarily show that the Forest Service in that case didn't actually practically address the impact to man's environment, which under NEPA is all powerful. You have to make room and balance for the species and the animals and your environment. But man's needs prevail in a practicable balancing set, which if the impacts haven't been made, is incorrect. So they go down that, they might have a chance. Thank you for tuning in today. As I looked up almost in too late. Appreciate you tuning in. I really do. Pass around the podcast. Grimner, thank you very much on libertymedia.com, reallibertymedia.com for y'all. Listen to the broadcasts all there. Jules at ucy.tv. Thank you very much for your recast, prodcast, and pastcast. And folks, just do what you can. It's out here. I get kind of excited, but it's just I want you to know this stuff and move on, and we can get on with life and really enjoy what the big world has for us. Thank you for the terrestrial broadcasters, what you do, and the freedomsnetwork.com, and all y'all that do support the broadcast, and those of us that support the means by which the platforms are done. Again, Grammy Mary, thank you very much. I'll be here next week, tech diffs and nature willing. Well, that's another lesson. I hope with today's information you can take it to those that misbehave. From behind the woodshed, leaving his mark on the beast, this is Hal Anthony. Till next time, journey with purpose.
So that's what opening up a can of whoop-ass feels like.
Son, you just opened a whole case of whoop-ass.